Yes. Oh, yes. Further area? Yes. Yes.
I stopped allowed yesterday. Are the other rules declared by the Lord promulgated by the state of Karnataka would be applicable to grade of district judge, seniority rules, and other various rules, except certain provisions of the general recruitment rules. I have already read over to your Lordship, Lord, the Rule 3 of the 1983 rules and Rule 11 of the 2004 rules. Rule 11. No, my Lord. Therefore, my submission to your Lordship is, my Lord, the opinion rendered by the senior judge, according to me, is contrary to law. And the rendered senior judge gives a finding in para 46. I draw to your Lordship, my Lord, that other rules are not applicable. That is contrary to law. Next question, my Lord, is as far as fast track judges are concerned, what is the position, my Lord, in India, not only in Karnataka? But
does that question come again here?
yes, my Lord, I have raised two questions. Quota breach. But fast track judges are entitled the seniority from the date of their appointment or substantive appointment. That is answered by Apex Code in not one or two judgments, number of judgments.
It is answered by the division bench. The division bench answered. Earlier division bench has answered that either.
But that is a settled issue, isn't it, by the division bench?
Earlier division.
Our division bench never said. What division bench said is, from the date of vacancy arose, you assign seniority.
Correct.
Question is no, my Lord, vacancy or base, post based. Basic question, my Lord, this bench has decided, is it a vacancy based or post based classification?
But can we now reopen that question?
My Lord, it is answered by the Apex Court.
No, but correct. What our question is, now the division bench has settled that issue.
No, it has not settled, my Lord. It has said, you find out. You find out.
No, it has said redo in light of the observation.
Yes, my Lord.
Isn't it?
Yes.
So how we can reopen that question?
In the light of observation, my Lord, is that registry has to work out.
Correct.
Having regard to cadre strength.
Correct.
If cadre strength is decided,
Correct.
Lord, rightly, cadre strength notification is concerned, I showed your Lordship, up to 2010 High Court has given the particular annexure fee. Thereafter, it is not given at all.
It's not definite.
Yes, my Lord. Therefore, my Lord, while redoing, my Lord, it has to be done.
That bank is for Satish, he can tell.
Redo the list ಹೇಳಿದ್ದ
It is for him, Satish, he can tell.
has redone, but it is not in accordance with the division bench order.
The registry has redone. It is not in accordance to the reason bench judgment. If reason bench has vacancy based.
That point we have to.
Yes, my Lord. Now, question is now, my Lord, again they have withdrawn that list. So everything is kept open. So registry, if it is done according to division bench, all right. It has not been done. Because basic rule of seniority, classification of vacancy or post based. At least some statement must be given accompanying the seniority list.
If your lordship is any seniority published by the state government, the first page would be the vacancy.
Probably my lord has come across number of seniority list when while sitting in roster bench. In any seniority list of any my lord state government, any my lord any cadre, first it must be accompanied when there is a quota with the my lord statement of classification of post bar vacancies. In the absence of any basic rule, my lord, of seniority is followed by the registry
And formation of block period.
and formation of block period. My lord has to say something about it, how to redo it. Probably my lord has to say, according to me, the division bench has said it is a vacancy based. In fact, my lord asked me a question yesterday, how High Court has given the vacancy based classification yesterday. I told vacancy based classification is done. Division bench also says you based on vacancy, you do it. That is the my lord division bench judgment. Para 67 Lord Division Bench says Badami applies. Maybe Badami is state of Mysore. That means vacancy based principle should be applicable while classifying the vacancy. My lord has to say no, it is not vacancy based because recruitment rules itself says Lord, it is a post based classification. Right from 1983, Lord, I pointed out to Lordship Lord, cadre strength is based on the post based only, not vacancy based at all. Therefore, settling or resetting the principle never arise because the seniority is concerned, it has not followed any law, either division bench or any lord. On the face, I have showed you annexure A and then both seniority I have shown. Even assuming for amount division bench is correct, lord. Whether seniority is prepared in accordance with the direction issued by the division bench. According to me, nothing has been followed. On the basis, on the face of the seniority list, which I produced annexure A and established that no principles of seniority is followed. Even all officers born in the cadre is not there in the seniority list, Rule 10, which applies to the judicial cadre. Not so, my submission to your lordship, Lord, as far as Lord, the fast track judges are concerned. But kindly know why, Lord, I am making my submission. The division bench has not given a finding. You do it. But all the serial number 38 to 82 were appointed as fast track judges, Lord, by 3 different orders in the year 2003. In the year 2003. Then, my Lord, the date of the Lord, their appointment is 2003, my Lord. I will give the date also, my Lord. 15 to 2003, 19 to 2003, 15/11 2003, 2/3 2004, 23 2004. Lord, if the suppose there is no order of substantive promotion, my Lord, probably that would have been, finding would have been given, but there is a substantive promotion, Lord, on 11/16/2009.
Correct, but we can't go beyond that.
Lord?
We can't go beyond the order of the division bench.
But division bench never said you, Lord, use the date of date of promotion as temporary judge. No, division bench said you retrieve it.
Correct, but the division bench said that though 2009 was the orders, you can go back to when vacancy arose.
If it is permissible.
No, that's what the division bench said.
Yes, Lord. Yes. Division bench said, Lord, if it is permissible, vacancies are there. You determine it. That there is no such determination at all in the seniority list. That question my lord has to say.
Yes, yes,
My lord has to examine at least, Lord, the principle head of division bench is implemented. Is it their case on the face of the seniority list? I'm not, my lord, asking this court to revisit it at least. At least see the principle head of the division bench. See the law laid up by the apex court as far as not the fast track judges are concerned. My lord has to say something about it. But in view of the not categorical finding of the division bench in Kumar Gupta's case, not the Supreme Court in Yamini's case, not para 73, which I produced along with the list of citation. Particularly, decides the question is framed by Supreme Court whether fast track judges appointed are entitled to seniority from the date of their appointment. Question is answered, my lord. They are not entitled seniority. It is answered, my lord. They are entitled only pay protection and pension protection. So none of the, my lord, fast track judges will be affected by your lordship's, my lord. Suppose if direction is issued, because their full pay protection, pension protection is there by the honorable apex court. My lord has to take note of the Supreme Court judgment as a division bench judgment. Even both, my lord, taken into account, my lord. Yamini case, my lord, Supreme Court answered that question particularly. Particularly, it answered the question. In fact, in my lord, the Dinesh Kumar Gupta's case, my lord,
For a moment, division bench has directed antane and division bench has directed to redo the seniority exercise alla with a particular direction.
Yeah.
Whether that direction is complied or not is to be considered. It does not amount to revisiting the. Huh?
ಈಗ ಜಡ್ಜ್ಮೆಂಟ್ ಫಸ್ಟ್ ಕುಮಾರ್ ಗುಪ್ತಾ ನನ್ನ ಯಾಮಿನಿ ಇಷ್ಟ ಸಜೆಷನ್ ಬೇಡ ಹಾಕಿದ್ದು
And the first citation.
ಹೌದು. But we are not parties to the judgment of the division bench,
But
nor the private respondents party.
correct, sir, but there is a difficulty.
Yes.
We may not be able to go beyond what the division bench has said. Now, though we may be with you on the point that the Yamini and that other
Yes,
judgment
Lord.
appears to indicate law contrary to what the division bench has said. We are with you on that, but it ends there. Now, the fast track court judges got some benefit by virtue of the division bench judgment, stating that though the order is 2009, the division bench said you can go a little further by taking the date of vacancy. But that you have
My
taken the view,
if-
it's contrary to Yamini and there's one more judgment.
Not only that, my lord. Not only that, but division bench is correct in saying vacancy based classification. My lord has to answer the basic question.
But how can we now reopen the division bench?
Right?
There appears to be some difficulty on that, but we will think. We will think, but there is some difficulty going beyond what the division bench has said. But we will keep an open mind, we'll see.
Not I'm making my endeavor, having regard to the recruitment rules, not whether post-based classification or vacancy-based classification. My lord has to answer that question. If the doctrine of post-based classification applies, my lord has to say something about whether vacancy-based or post-based.
So that we will say. That we will.
It is not revisiting, but I am only making my endeavor what recruitment is.
No, that point is well taken, what you pointed
Ah.
out, total number of posts.
Yes,
That we will keep in mind. We may have to take a view on that.
but at the same time, when my lord Roy is changed subsequently, because revision bench already spent its force, they have withdrawn that seniority list in the year Lord 21, published Lord provisional list, then again Lord the final list.
That we'll consider, but prima facie, there are some difficulties of revisiting the law laid down by the division. We can only after the division bench order we can see, but we can't go beyond what the division bench says. Prima facie view, but we'll consider.
Then my lord, if suppose my lord uh, says we are bound by division bench, this is three-judge bench, my lord. But the question now is, my lord, having regard to change of law by laid down by apex court, what is the effect of division bench? My lord has to say something about it.
We'll consider. We'll consider that.
Having regard to recruitment and truth, my lord has to prima facie decide whether post-based or vacancy-based. While deciding that, my lord has to see what apex court says about my lord the.
After the division bench, no seniority list has become final.
But I can understand the division bench seniority prepared person division bench has finalized. I mean, become final. No, it has not become final.
So the list has not become final.
Yes, my lord.
That we agree with you.
Yes.
The reason being that the list issued after that again has been redone.
Yes. Read.
And so far as the directions of the division bench, only in prospective we can see, but retrospectively reopening that we will think. We will think about it, but we'll see.
My endeavor to brought to your lordship is what apex court says this. This is the law laid by apex court I have shown.
You are right in so far as what Yamini says.
Not only Dinesh Gupta and Yamini both.
Both.
The
Correct.
particular question is framed and answered by apex
No,
court.
you are right in that. That we agree with you. That is the position.
That is the question applied. Learned judge also said so. Yes, you have to say something. Learned judge also directed to redo the seniority in the light of this. How to go. But at the same time, Lord, these Lord recruitment rules are also praised before the division bench. It has noted that it is a post-based. Kindly see the division bench judgment now. Volume 2. Volume 2, Lord, page 344, Lord. Retable paper.
ಇದು ಓದು ತೊಂದರೆ ಇಲ್ಲ ಒಂದೇ ನಿಮಿಷ. ಈಗ the list which was prepared.
Division bench judgment of the Lord, this court where
Previous judgment.
previous judgment, Lord. Page 3, it commences from volume 2. Judgment commences from page, Lord, 234.
ಇಲ್ಲ ರಿಟ್ ಅಪೀಲ್
Writ appeal papers ಅಲ್ಲಿ annexure B is order passed by division bench, Lord. Division bench to show that vacancy based post ಅನ್ನು ಮಾಡಿದ್ದಾರೆ ಅಂತ to show that. Yes, Lord.
ಹೌದು.
It is a how Lord court has viewed it.
No, that we agree. Prima facie, we are with you on that. The rule says post-based.
Yes,
Any other interpretation would be contrary to the rule.
rule.
That is well taken.
Yes, Lord.
We have made a note of that.
Lord, my Lord has noted para my Lord 60, court gives a finding what is the quota. Para 60 already pointed out to your Lordship, my Lord. Then, my Lord, para 67, my Lord, why I am making this endeavor, court, my Lord, division bench says, principle laid down in, my Lord, V.V. Badami would apply. Para 67, my Lord. And this is the last entire paragraph only with regard to Badami only. And division bench further says, direction is, fast track judges are concerned with promoting in direct recruits. Vacancy based classification they have produced. Direction is issued, my Lord, based on vacancy based classification. Condition, my Lord, para 84, para 83 and 84 is a direction, page 400. What is the direction? Lord, RG is directed to prepare a fresh seniority list. Kindly see, my Lord. Page 400, my Lord. Got it?
No, but I have a different take on that interpretation. Now, the division bench
Yes, Lord.
said that though they were appointed in 2009,
Yes, Lord.
you can date their seniority by treating their appointment when vacancy arose.
Yes, Lord. Therefore.
That is different from saying filling up is vacancy based.
Yes.
Here the court was dealing with the aspect of seniority
Yes.
and said that though they were appointed substantively in 2009,
Yes,
court interpreted the word substantively
Yes.
to say no, though they were in 2009 the order of appointment, however you can go beyond that.
Yes.
It said, but it's not. We can't take that to say recruitment and vacancy must be vacancy based. Filling up of district judges posts are as per the rule post based. Quota is percentage of the posts.
Yes. 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 My Lord is right. I'm not there. I'm not. Because my endeavor is only post based. My Lord is right also.
The rule says
Rules also says post based.
Our division bench says
Division bench says, my Lord, para 67, I showed your Lordship, Badami would apply. Lord, I'm making my endeavor.
seniority is after the division bench order has not been finalized.
yes.
Umbrella of Supreme Court.
But number one, seniority list has not become final after division bench judgment, nor it is prepared according to law. Fast track judges are concerned, they are entitled to protect everything except seniority. That is what Supreme Court said. No way, my Lord, if directed also you do it as per the apex court judgment, they will not be affected. None of them will be affected. Supreme Court has protected them in 20 back, not only in 2023 also it says so.
It will not affect them.
Yes.
After this can affect them.
My Lord, why I am making
Yes.
Lord, division bench, Lord says, Lord, you please redo it. If access is there, push down. Lord, that is what the division bench observe. Either promotees or direct equities. It never said, Lord, you give prior date. If it is available, yes, you give it. If it is not available, do it according to Lord working out quota. But I think resuscitation ಇದ್ದರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
But I have given all the judgments of Dinesh Kumar Gupta in the list of citation and my lord Yamini also. List of citation 1, my lord. Have I to draw your lordship's attention to a particular paragraph? I don't think it is necessary. If it is necessary, I will point out now itself.
18/9/2024.
89/2024. Dinesh Kumar Gupta question frame ಮಾಡೋದು.
187.
187 my lord. Because particularly seniority of fast track judges it is dealt.
Page 244.
Para?
Para 40.1.
Not para 40.1 my lord.
Page 244.
Page 244. Yes, my
Dinesh
lord.
Kumar.
Para 40.1 capital A is a question framed by the apex court. Page number 244. But it is only my duty to bring your lordship's notice. How to consider I leave it to the bench. Whether the judicial officers promoted on ad hoc basis as additional district session judge to man the fast track courts in the state who are substantially appointed to the district judge are entitled to seniority from the date of the initial ad hoc promotion is a question number 1. Not answering that question is answered.
Para 42,
Yes, Lord.
page 251.
Para 42.
42 and 43.
Yes.
251.
251.
ಕೊಡ್ಲಾ?
But referring to all judgments, 42 finding is given. The decision in so and so case, where the context where serving judicial officers were granted ad hoc promotion as fast track court judges, while C. Yamini and members of the bar were appointed fast track judges, and these decisions thus completely conclude the issue. As it has been held in the said decision, the reckonable date has to be the date when substantive appointment is made, not from the date of the initial ad hoc appointment or promotion. Therefore, answered in the negative. Then, my lord, in Yamini, not page 269,
269.
269,
Para 7.
para 7,
272. Page
272, para 7. Ultimately, court may not gives a finding at para 8. Since the service rendered by the petitioners, page 274, as fast track court judges have not been recognized by this court for the purpose of seniority, except for pensionary other retirement benefit. The plea raised by the petitioner to consider service rendered as fast track judges as special service, as judicial service for the purpose of Article 217(2)(a) of the Constitution in the light of the judgment of this court, what being prayed for is not legally sustainable. Referring to Article 217(2)(a), they refer.
There's one way of reconciling.
Yes, my lord.
The division bench, Yamini
Yes.
and Dinesh Gupta.
Yes.
The word substantive appointment.
Yes, my lord.
So say the fast track court judges were appointed in 1982
Yes.
and they worked for 3-4 years.
Yes, my lord.
One way of looking at it is
Yes.
the substantive appointment order
Yes.
could have been made
Yes.
by taking note of the date when vacancies arose in that case. So for instance, they worked for about 5 years.
Yes.
About 10 vacancies arose in the third year.
Yes.
So you could have made an order appointing them in a substantive appointment from the third year.
Correct.
No doubt you can't go to the ad hoc appointment.
Yes.
That question doesn't arise.
Yes. Yes.
Because that was only ad hoc.
Yes.
So this word substantive, the later division bench appears to have indicated that 2009 was not substantive. That appears to be the understanding of.
Yes. Yes, my lord. That is what the division bench observed, my lord. I am not saying that. I fully agree with you, lord. But at the same time, because law is changed subsequently by Supreme Court, particularly framing the question, my lord has to,
And in the light of non-finalization of the seniority
in
list.
the light of non-final seniority list, my lord, I can understand seniority has become final. No. Because seniority has never become final after the division bench.
So vis-a-vis is fine. There's one logic.
Yes.
Vis-a-vis fast track court judges.
Yes, my
You
lord.
can't place them worse off than they were before the division bench. Who came to the court? Promotees came to the court in 2013. What did they challenge? Don't 2009 is wrong date. You give us seniority earlier. Now we can't push them further down because they have the benefit of having consideration beyond 2009. So they can't now be placed worse off than they were when they appeared, when they went before the division bench. But we'll consider what is the consequence of Yamini and Dinesh Kumar Gupta vis-a-vis relook into the final seniority list which was still open
Yes,
and not final.
therefore, I am making endeavor, my lord, since it has not become final, my lord has to send something affects court judgment. In the light of this, the question framed by the apex court, subsequently consistently followed by the apex court, law is changed. Change of law has to be taken into account while rendering the judgment is my endeavor before your lordship. That much, Lord, I can gladly say.
So contention is when the seniority list is required to be redone.
Yes, Lord.
The law existing as on the date when the seniority list is to be finalized. That is Yamini, Dinesh Kumar
Yes.
Gupta must be taken note.
Yes. Take a note of it.
Yes.
Yeah. One.
Who are the appellants before the division bench?
Promote is correct. Correct. Therefore, my endeavor is, my lord, why not take note of the subsequent change in law and maybe reach a directive taken to this account of a court judgment while redoing the seniority list.
Yes.
Not the private respondents who are the appellants. Therefore, my submission to Lord, as far as fast track judges are concerned, Lord, judgment of the FX court change in law wholly failed because it binds not all the high courts in India as per fast track judges are concerned. Then, my lord, the private respondents have said, Lord, as appellants, necessary parties. Lord, according to me, my lord, this issue is not raised before the single judge, nor before the, my lord, division bench. Necessary parties are there already. 82% are parties, promotees. In what I need not make on 82% as a parties. In the light of the principle led by Supreme Court in the matter of seniority, in VP Srivastava case, my lord, Supreme Court says, page 29, my lord, I called out. Even a representative capacity, 2-3% made a party. Here I have all of them I have made a party. They may be prejudiced by the judgment. And in the light of the, my lord, Janardhan, my lord, page 30, para 15, my lord, I called out. In the matter of seniority, principles shall be laid down by this court. In fact, I need not make them parties at all. My lord can lay down the principles, free to do it. Nothing else. This court cannot calculate, though I have given the table, nor other parties might have given the table. I have also given the table. Court only lays down the principles, free to do it in the light of the principle laid down by this court. Therefore, my endeavor, my lord, is that since the private respondent appellants have not even filed reply statement before the learned single judge, nor that question is raised before the revision bench also, whether this court can go beyond the, my lord, the reference. My lord, this bench has to give a finding whether which view is correct. Respondent, my lord, 13 to 82 are directly affected parties. I made them parties. Therefore, question of, my lord, making, my lord, other parties, other promotees are necessary parties, my lord, is never, my lord, not the question nor raised. It cannot be examined, and it is sufficient to make them 2-3% a party. Here I made all of them a party. Then, my lord, yes, my lord, the question now, just, lord, next is the cadre strength, page 36, lord. My lord, I showed your lordship, my lord, annexure A and annexure N both. Annexure A shows increase in cadre strength in everywhere. Kindly for a moment, my lord, recollect the volume 1, A seniority list. But page, volume 1, page 184. Then I will come. Lord, page 184, remark column, my lord. Kindly see, my lord. But everywhere they refer increase in cadre strength. Kindly see, Lord, remark column, annexure A, page 185 onwards, my lord. But there is no, it commences from serial number 38. Serial number 38. It has no significance at all. Why serial number 38 alone? Why not all the officers born in the cadre? Nothing is shown, simply final seniority list of district judges. It says that's all. Now, this remark made due to increase in cadre strength is vanished in, my lord, another final seniority list prepared in annexure N. Kindly take now annexure N comparison. Here, remarks column, they say every time, whenever due to increase in cadre strength, they go on telling, my lord, that everywhere. Due to increase in cadre strength, serial number, Lord, for example, Lord, serial number 49, then Lord 63 onwards. Everywhere they comment 188 due to cadre strength. Whereas annexure N, page 548, volume 2. Volume 2. Volume 3. Volume 3. Volume 3, yeah? Volume 3, volume 3, 548. Because comparison of both annexure A and N in the column, my lord. not nowhere, not that remark is vanished. Nowhere it is there. Due to increase in cadre strength is not removed. How they prepare this list, not except not saying that High Court says not date of entry and date of promotion is taken into consideration. Therefore, we are placed the respondent 4 to 12 below this not respondents. There is no change in serial number, 38 only. When my lord, I file a rejoinder pointing out.
Yes.
Madam, the para 36, I without even saying what is the cadre strength of district judge. Not I pointed out, not this is the increase at the 26 officers. Without taking not 35% excluding that. But I am making not page 36, not that is the table I have given, which is not is correct also. High Court block takes stand in third rejoinder, 340 post is existing. Therefore, we have worked out the quota 340. It is not even reflected basic not rule of seniority statement of not post is given. I would have worked out. I would have said to this court, but nothing is worked out. They say Lord, they justify the third rejoinder 314 are existing. We worked out like this. But now, my lord, coming to the notification produced by the High Court. But there are two memos filed by the High Court. One is, my lord, dated 8/9/2020 before the division bench. First time that produced the government order. Then, my lord, one more is 7/1/26 before this. I think before this court. Before this court. Now. Kindly take the memo dated 8/9/2025. But I will point out here, not page 1 of the memo dated 8/9/2025 before the division bench. 15/2/2002 notification, Lord. My lord, that is establishment special court to conduct trial of heinous crimes committed by notorious Dandupalya Krishna gang. Headline, Lord. But I have already emphasized to your lordship, my lord, this creation of post is concerned. But I have already produced the Karnataka government, my lord, allocation of business rules 1977 in the list of enactment, my lord.
There is one difficulty.
Yes, my lord.
Without the High Court
Yes.
quantifying what cadre is.
Yes, my lord.
As per procedure, either procedure A or procedure B.
Yes, my lord.
Unless cadre is quantifiable.
Yes, my lord.
As per some criteria.
Yes.
Merely 1 + 1, 2 + 3,
No, my
4 + 4 is
Yes.
not possible.
Not possible.
We can't enter into that
At all.
exercise
Lord, I am only.
unless there is some certainty with respect to cadre.
Yes, my lord.
That the High Court accept till 2010.
Yes, my lord.
After which there is no single notification which shows what
Two-
is the strength.
2001, my lord. 33, 2001. I showed you a lot. Yes, my lord.
Then to some extent till 2010, to some extent till 2010,
They give the statement of,
they give
yes,
some
yes,
numbers.
yes,
But after that, there is no consolidated list of what constitutes the
cadre state, cadre state. Unless there is a general notification like Kerala High Court, it is the ministerial duty of the registry to point out this is the creation of what we will count it. There is no general notification like Lord Kerala High Court where Kerala examined. Here in Karnataka is concerned, no, my lord. There is no such government order. No, my lord. I'm making endeavor to say, my lord, point out, my lord, this 15th February notification 2002 establishment of, my lord, Dandupalya Krishna gang trial of that court, trial of that case, my lord. It is created, my lord, by the DPAR in consideration High Court, my lord, Kandisi, page 2. These posts have been created initially for a period 1 year, only from the date of this order, and prior to approval, the government should be obtained, continue for a tenure of these posts. Lord Kandis is the last in that notification. This order is issued in concurrence with Finance Department, so and so. Lord got it, page 2. Why I am pointing out, Lord, this creation of district judge is concerned. Kandisi, no new recruitment should be done to the new post. That's what my observation in the very government order. That means to say the court is established for a particular purpose.
Condition number 5.
Condition number 5, my lord, in the order. No new recruitment should be done to the new court. And this order is issued in the Finance Department. But I have already pointed out to your lordship, Lord, allocation of business transaction rules, particularly the subject matter of finance is concerned, High Court and District Judge is concerned, it is allocated to DPAR under the business transaction rule 1977. Lord, I already showed your lordship, Lord, rule 17 of business transaction rules is concerned. Every post, creation of post to determine the cadre strength also, concurrence of finance department is necessary. Any department, state of Karnataka. This cannot be, my lord, included in the cadre strength at all. Page, my lord,
Fake,
page 6,
fake stamp.
fake stamp. Same.
But there's one point
Yes,
also that comes out from argument. While they say that once financial concurrence is given, notification is passed, that by itself is sufficient. That is their argument. However, it is your argument that cadre must be done according to a certain procedure, and in terms
Yes,
of
Lord.
the KCSR rule, there must be, as in the 2001 notification, there must be quantification of cadre. So according to you, this this reliance placed by them on government notification for creation of special courts, etc., even otherwise cannot constitute as altering the cadre.
Yes, my lord.
That is your argument.
Not only my argument, the order itself says continuation of this post shall be with prior concurrence of the Kandisi, that also prior approval of the government. Finance department shall approve it. Otherwise, not very difficult to continue those posts at all. Because Rule 17 mandates in state of Karnataka, any post if you create in any department, not finance concurrence must be. Numbering of post, increasing the post, everything, Lord, shall be in the concurrence of the. I showed you, Lordship, Lord, 24 notification, where cadre selection grade and Lord superintendent scale is increased. That in concurrence of the finance. And 24 to 2006 also, fixing the percentage of working out 25 plus 10 in the cadre selection grade and super time scale. That is in concurrence of finance department. Then not everywhere, no new recruitment should be done to this post, new post.
Page 7.
Page 7, my lord. Page 7, my lord. This is regarding fake stamp also, same Lord. Fake stamp. For one post is created. Same line.
ಸೇಮ್ ಮತ್ತೆ ಓದೋದು ಬೇಡ. ನೆಕ್ಸ್ಟ್ ಟ್ರಯಲ್
ಜಯಲಲಿತಾ ಹೇಳ್ಬಿಡ್ತಾರೆ.
ಬೇಡಪ್ಪ ಅದು
ಕೇಳಿ ಬಿಟ್ಟು ಹೇಳ್ತಾರೆ. ಬಯಾರಿಕೆ ಆಗ್ತಿತ್ತು. But a case relating to Lord trial of a fake stamp, same Lord ditto notification. Lord fake related to case against Kumari Jayalalitha is the same notification. Not terms notification is issued.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತೋರ್ಸವ
ಏನು
ರಿಜಿಸ್ಟ್ರಾರ್ ಅಡ್ಮಿನ್
ಅದನ್ನ ಹೇಳ್ತಾರೆ.
ಬೇಡ ಅಂದ
ಅದನ್ನ ಹೇಳ್ತೆ. ಹೇಳು
ಬಿಡೋದಿಲ್ಲ.
ಹೇಳು.
ನೆಕ್ಸ್ಟ್ ಪೇಜು ಇದಾಗುತ್ತೆ
ನೋಡ
ಮುಂದೆ ಮುಂದೆ
ಡೈರೆಕ್ಟ್ ಹೋಡು ಇಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ
ಇದು ಬೇಕಲ್ಲ ಅಡಿಷನ್
ಇದೆಲ್ಲ ಒಂದೇ ಒಂದು ನಿಮಿಷ ಇದೆಲ್ಲ ಇದೆ
ನೆಕ್ಸ್ಟ್ ಜುಡಿಷಿಯಲ್
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಯ್ತು ಆಮೇಲೆ ಎಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಯ್ತು.
No, your point is well taken.
Yes, Lord.
Your contention that merely by these notifications, we can't construe there to be an addition to Cadre is a substantive argument.
Not only that, my Lord. Not only that. Lord, ಖಂಡಿಸಿ the registrar administration in the before this court. What is the method of recruitment, my Lord? Either by deputation or by promotion. Would it include in the Cadre of Techno, my Lord? Because then there are two modes of Lord possible. It cannot be included in the Cadre of Techno. In the same way, additional registrar in Lord Lokayukta is concerned, and registrar Lokayukta, but all Lord two modes of recruitment. One is my Lord deputation from the Cadre of district judge. Another mode is deputing IAS. Could it be included in the Cadre notification? No, it is not possible because it is impossible to include because two mode. It can't be uncadred. For example, I will give you an example. Law secretary. It is uncadred. Only Lord district judge shall be posted, deputed in Karnataka High Court. Such post Lord deputation Lord shall be taken into account, but not Lord when modes are, two modes are there. But I will point out to your lordship, my lord, that page 26 in the notification, for example, page 26, for example, I will show you 2-3 example like that. Page 26. But Registrar General, when I got it, my lord, Registrar General, selection of a person who has been district judge. It is a post in the High Court.
So your contention is that these OOD posts, what they say, cannot be counted as
Unless,
addition
Lord,
to the cadre.
yes, unless it is included in the cadre notification. I showed your lordship 2000 OOD reserve is included. Unless these posts are included, then they cannot be.
Yes.
Lord, Registrar Judicial, for example, my lord, Kandisi, next, my lord, there are two modes of recruitment. One is, my lord, selection, my lord, from the post of district judge, or by promotion of selection person in the deputy registrars. Deputy registrars, they are High Court employees. When two modes are possible, can it be included in the cadre tank? No. Then, my lord, in the same fashion, my lord, registrar administration, my lord, two modes of recruitment. One by deputation or by promotion. That can't be included. Then, my lord, can you see the director 3B, for example? Not by selection, who has been district judge, correct. It can be if it is notified. But can you see director of training, two modes of recruitment. One is by from the cadre of district judge, another is, my lord, can you see retired district judges. It can't be included. On contract basis even. There are post establishment in the High Court. It can't be included in the cadre tanks at all. But I will give one more example for kindly take page 73. Lord, I have page 73, my lord. Lord got it, Lord. But kindly see the principal district and such as Bangalore rural district. But can a district entry level can be posted there, my lord? Kindly appreciate this, my lord. All 29 posts are, it is super time scale post. Could it be included in the case district entry level, my lord? Kindly see, my lord, principal district and section judge, rural district. My lord's experience as administrative judge, who can be posted as PDJ? But can an entry level district judge can be posted directly to a district judge? My lord, PDJ? No. It can be included only cadre strength of district judge super time scale. Not kindly see number 2, number 3, principal district judge, session judge Belgaum, principal district judge Bidar. All this, my lord, they say, Lord, we have counted for the purpose of district entry level. Could it be, Lord? Could it be? Lord, in the light of the government order dated FX court judgment in 2002 and government order dated 24/3/2006, Lord, 25% shall be reserved for district selection grade from the district entry level and 10% for not for selection grade to the cadre of the super time scale. Would this be not part of cadre tank? I myself ask this question. And according to me, my lord, this post cannot be included as entry level cadre at all. I will show you, your lordship, lord, again. For example, my lord, in some notification, they say this notification 73, my lord, almost all 29 posts pertaining to the, my lord, super time scale post. except not 2, 3. They say this also will count. But page 75, my lord. Again, item 6 onwards. Pradhana Nyayadhisharu. My lord, all these posts cannot be counted because it is in the super time scale. Page 75, my lord. It cannot be part of the entry level renew of this apex court judgment in the light of the High Court Lord concurrence, the executive order dated 24/3/2006. It cannot be part of Cadre. I am only making an endeavor to say, my lord, they cannot be included in the Cadre. Even it is notified, it can't be included at all. Even my lord, DPI notifies it. DPI already notified what is the cadre strength of blood selection grade, what is the cadre you should resolve for it, and selection grade. I am in a super time scale. Have I to draw your lordship attention again 24/3/2006, which I have produced along with the list of enactment. For a moment, Lord, I will just to glance it to say these posts cannot be included. Twenty-four, 3/2006. Page, my lord. Page 36, my lord. 36 commences. Then, my lord, page 39 at the end, my lord, while implementing the FS court judgment, they say, my lord, 25% of the cadre strength of district judges, it will never say, my lord, 25% of the cadre strength of district judges who have completed not less than 5 years continuous service in the said cadre shall be eligible to be considered for promotion to the cadre district judge selection grade. Pay scale is mentioned. Would it include this post in the cadre strength? No. Would it include next page, my lord? Page 40, 10% cadre strength of super time scale? No. Both shall be excluded. And they will not produce those documents to show, my lord, that you include that also. But the court has to lay down the, my lord, law. Such posts can be included, my lord has to say. Otherwise, High Court will commit again, registry will commit the mistake.
Yes.
Therefore, my submission to you, lordship, my lord, now coming to the additional registrar post, lord, in the Lokayukta. What is the mode of recruitment? They themselves say 2 modes. Can you see, my lord, that in the in this memo, my lord, page 4 of the my lord memo, this memo. Post of, for example, registrar administration, not page 4. They admit, my lord, 2 modes of recruitment. They themselves admit. Then, my lord, cadre recruitment Karnataka State Administrative Tribunal, post of registrar, 2 modes of recruitment. One is, my lord, deputing the district judge. Another is, my lord, promotion from the cadre district deputy registrar. Would it include when 2 modes are prescribed? Then, my lord, again, addition registrar, my lord, kindly see that also. They admit, my lord, there are 2 modes of recruitment, IAS or deputation from the cadre of district. How did it include the, my lord, these posts? My lord? It is impermissible to include. For example, my registrar case 80 can be filled up by 2 modes. one either from the district judge or from the promotion for the deputy registrar. Additional registrar of Lokayukta, either deputy district judge, merely we have deputed, we are paying salary, could it be included not in the cadre tank? And they admit there are 2 modes of recruitment. Tomorrow go DPI will say, no, we don't want, we will say we will post only IAS officer. What will happen? Therefore, 32 posts which I mentioned cannot be taken into account, 30 posts into cadre strength at all. Notwithstanding, my lord, I showed your page 73 where principal district judge also included in the cadre according to High Court. My lord has to say something about, because at least future guidance will not say, not only in this case. Therefore, this court has to lay down the law. What should be included in the cadre strength? Would it include not post by which 2 methods are suggested, either by deputation or promotion? That is a post existing in Karnataka Lokayukta cadre and recruitment rules. Lord, kindly take for a moment. It is a staff in Lord Lokayukta, and 2 modes are recruitment. Now tomorrow DPR may say no, we will post only IAS. Can High Court take into account those posts as a cadre strength, Lord? No. Lord, kindly see the page 88 of the Karnataka Lokayukta Act.
So your point is well taken.
Yes.
That what you are saying is, if there are 2 modes of recruitment, one internal and then by deputation of district judges, you can't take +1 because you don't know when, how you can fill it up.
Yes, Lord. Registrar, Lord, for example, registrar, not Lokayukta. Kindly, court officer, page 140 probably. How? Different book, but Karnataka.
Schedule.
Lokayukta, Karnataka Lokayukta, cadre recruitment and condition of service of the officers. Employees rules 88. Kindly take schedule, second schedule in the recruitment rules. What is the mode of recruitment?
Page 76.
Not registrar, not Lokayukta, by deputation of an officer. By deputation of an officer in the cadre of district and session judge of the Karnataka Judicial Service, or an officer of Indian Administrative Service, or for posting Indian Administrative Service, or by posting additional registrar. 3 modes of recruitment here, registrar, not Lokayukta. They say this should be included. Next, additional registrar. 6 plus plot 1. 7 post there. Not additional registrar by deputation of an officer in the cadre of district and session judge from the Karnataka Judicial Service, or an officer of Indian Administrative Service, or by promotion an officer in the cadre of deputy registrar. There are 3 modes of recruitment. Would it be permissible to include, my lord, those cadre in the district judge cadre? Law will never permit such posts can be included. Even the cadre strength is notified for a moment. It cannot be included. Not 1 or 2 modes, 3 modes there. Therefore, my submission to your lordship is, my lord, the notification creation of post itself cannot be a cadre strength unless but Lord cadre strength notification is issued under KCSR Rule 8 subclause 7 read with definition of permanent post and temporary post 34 and 46 subclause 46 of the KCSR. When modes of recruitment are different, law will never permit them to include in the cadre strength of a district judge. Whether post of principal district judge can be included in the cadre strength of district judge entry level, my lord has to say something about it, which I showed your lordship the notification also. It's a part of cadre strength, they say, my lord. There are nearly about 35 posts. And my lord, as far as a family court is concerned, again, my lord knows how many posts are there. And posting of a my lord, principal district judge is concerned, my lord's experience as administrative judge certainly would assist that to interpret. Nobody else been posted as principal district judge, not entry level. But a post of principal district judge cannot be included in the cadre strength of district judge entry level. Post, my lord, on deputation when modes of recruitment are different, more than one, cannot be included in the cadre strength, my lord, at all. My lord, therefore my submission to your lordship is, my lord, cadre strength, my lord, as defined as my lord, the argued by the High Court, my lord, cannot be accepted in any manner. Merely post is created, no. For example, debt recovery, my lord, tribunal presiding officer, a retired district judge will be appointed. Could it be included, my lord? But registrar in my Supreme Court committee, could it be not included in the state of Karnataka? Registrar judicial, registrar listing in the Supreme Court, could it be included in the state of Karnataka? There are many officers deputed from Karnataka as registrar administration, registrar listing. Could it be included in the cadre strength, my lord? Because Supreme Court can choose any of the district judge all over India, not only from Karnataka. They can choose. Could it be included? They say no, all those posts are included. Debt recovery tribunal, human rights commission, all those posts are included. They say, my lord, in the notification which they produce. For example, my lord, the director of arbitration center, who will be appointed, my lord, knows. Either for deputation or retired district judge will be appointed director of the arbitration center. Could it be included? But all this, my lord, exactly the question, rounding, my lord, here. Merely High Court says that these you please include it. My lord has to interpret and say whether it could be included in the part of cadre strength and then classify the post and redo the seniority list. That is my endeavor, not to your lordship. According to quota. Then, my lord, M.E. Dikshit for state of Karnataka. I need not again repeat, my lord, that M.E. Dikshit state of Karnataka is concerned. It has no application here. Why? Because, my lord, High Court, while examining the abolition of post and creation of post in public cost department, and by an executive order you cannot abolish or create the post. It is only the provision of section 3 and 8 of the 1978 Act, Karnataka Civil Service Act would apply. You can create the post, abolish the post in accordance with law. That is the law in M.E. Dikshit case. Your number of posts also. But however, M.V. Dikshit was state of Karnataka is not no more not in the statute because in the year 2010 Karnataka Civil Service Act, although 3 is not is added, stating not as far as number of posts. Kindly see for a moment that the M.V. Dikshit case is concerned, it is no more not holding the field. The very Service Act itself is amended in 6/5/2010. Proviso to 3, last proviso probably. Kindly take Karnataka Civil Service Act. I have pointed out earlier.
The MV Dikshit is prior to the amendment.
Yes, yes.
Civil service.
Karnataka Civil Service Act 1978. Now, M.E. Dikshit is rendered in the year 2004, Bernard. 2004, reported in 2004. Kindly see section 3. Section 3, Bernard. 1A. Subject to the provisions of this Act, the state government may, by notification, make rules specifying the different categories of posts in the different branches of public service in the state, the total number, nature of posts in each category, and the scale of pay admissible to each category. I will pause a moment, stop for a moment, Lord. Kindly see the proviso added on 6/5/2010. It's unnumbered paragraph, my lord. Paragraph proviso. Proviso, my lord. What?
Section 3 2.
Section 3 2. Lord. Sub proviso unnumbered 3. Not got it. It is there, not. Provided further that nothing in clause A shall apply to the rules specifying the number and nature of the post. That means to say, my lord, M.E. Dikshit interpreted section 1A. 131A. Not kindly note it. 31A is interpreted to hold that creation of post, abolition of post, everything shall be is covered under 31A. To wipe out the principles in one of the M.E. Dikshit case, basic is removed, then proviso is added, stating that further nothing in clause A shall apply to rules specifying the number and nature of the post. It will not apply. Therefore, M.E. Dikshit is concerned, it is not holding the field at all in your amendment. That amendment purposefully introduced because of overrule the principle laid down in M.E. Dikshit case.
By means of executive order also post can be created.
No, my lord. By an executive order, post can be created. Because 3(1)A, M.E. Dikshit interpreted, proviso is added. No need to publish, my lord, the rules numbering the increasing the post or reducing the post. No need to publish the draft rule at all. Straight away they can issue notification. Because proviso is exception to 3(1)A, my lord. Section 3(1)A.
Recruitment rules may not be amended.
For example, recruitment rule is concerned, number of posts, increasing cadre strength. Recruitment need not be amended. Proviso is added to say government has power to issue notification. Prescribe the number of posts. Immediately says, no, 3(1)A is interpreted by way of rules only you have to do it. No, my lord, it is wiped out. Therefore, Lord, M.E. Dikshit was the state of Karnataka is no more good law because it is a rule is amended. Kindly take note of this thing. Lord, as far as C.V. is concerned, division bench of this court interpreted some provisions of the direct recruitment. While examining that 78 Act, no application to as far as framing of recruitment rules of district judge or judicial service is concerned. Correct, Lord? It is a provision under Article 233 and 34 and 35 of the Constitution only, my lord. Rules can be promulgated by the DPR in consultation with the High Court. That is the law also. 78 Act has no application. To promulgate the, my lord, rules pertaining to judicial service. It is only, my lord, 233 through 34 of the Constitution provision provides that. Lord, I already, Lord, explained to your lordship, Lord, Karnataka Civil Court Act has no application defining the cadre tank, because Article 236 itself, Lord, defines what is the, Lord, expression district judge. But kindly for a moment, recall my the first argument while, Lord, explaining the provisions of law. I explained the Karnataka Civil Court Act 1964 has no application because only jurisdiction of the civil court is stated in the Karnataka Civil Court Act, nothing else. Article 236 itself interprets what is, Lord, expression district judge. But for a moment, Lord, Article 236, may I draw your lordship's attention again. But page 51, I have called out in my synopsis, notes. Lord, kindly see page 51, interpret Article 236. The expression district judge includes judge of a civil court, additional district judge, joint district judge, assistant district judge, chief judge of small class court, chief judicial magistrate, additional chief judicial magistrate, session judge, additional session judge, and assistant session judge. It expresses what is district judge, post of district judge includes. There is an express provision under Article 236. A. B. Lord, defines judicial service. What is judicial service? Judicial service means only, Lord, kindly see, service constitutes exclusively person intended to fill up the post of district judge, civil and other civil judges post inferior to post of district judge. But whatever post existing below district judge is called Karnataka Judicial Service. But district judge is concerned, it is not for Karnataka Judicial Service at all. It is entirely defined by Article 236. Therefore, my lord, my submission to your lordship is not all, my lord, the 83 rules, my lord, of Karnataka, not judicial service is concerned. It is promulgated under Article 309 of the Constitution by the governor. 2004 rule is concerned, my lord. Wrongly, I have already, Lord, explained to your lordship. Provisions of 19th Karnataka Civil Service Act is mentioned in the preamble of these rules. But it is not so, my lord. It is only under Article 233, 34, 36, my lord. DPAR in consideration High Court can promulgate the rules. It has been promulgated. Now, my lord, the division bench of this court, Lord, expressed two views. One confirming the view of the learned single judge. Another view is, Lord, allowing the High Court appeal filed by the High Court. Lord, the learned Lord senior judge Lord, relies upon the division bench Kerala High Court. Lord, I already explained to your lordship, Lord, para 4 of the third judgment. Government or Kerala, Lord, the government order dated 30/4/2016 is interpreted, where the Kerala, Lord, state government, in consultation with the High Court, Lord, Kerala High Court, but promulgated the government order prescribing the definition of cadre strength, which consists of both permanent and temporary posts lasting make them 6 months. If it is below 6 months, don't include. That is the general government order existing in the state of Kerala in Calcutta High Court. While interpreting para 9, I showed your lordship date is also wrong. In the preamble of the judgment, it is quoted 34/2014, 38/2014. It is 38/2016. My lord, I requested you to correct the date also in the judgment rendered by the Kerala High Court. My lord, it has no application on the facts of this case. In law in Karnataka is entirely different. Apart from that, my lord, against the Kerala High Court judgment, Lord, SLP special leave is granted. Leave is granted. It is still pending. I have produced that order also. Number one, Kerala High Court judgment has no application. Number two, my lord, leave is granted by Supreme Court in any manner according to me, my lord, when it is leave is granted. That means, my lord, here we say, my lord, rule nisi. There, my lord, Supreme Court says leave granted. Either Supreme Court can grant the leave and allow the special leave petition, or Supreme Court say leave is granted, we will examine. That means rule nisi, admit. Lord, it relies upon the judgment of the B.S. Yadav case. Kindly take page 54, Lord, of the. Very interesting, Lord. Supreme Court examines the Lord contribution with Supreme Court in B.S. Yadav case, state of Haryana. Lord, I called out para 43. Having seen the
Yes.
my lord knows the allocation of business between the my lord, the state legislature and my lord, the central. Lord, Article 246, my lord, defines the list 1, list 2, list 3, my lord. List 1 pertaining to the my lord, parliament, list 2 is state list, list 3 is concurrent list, my lord. Lord, kindly see Constitutional Bench Supreme Court says, my lord, what it says is, Lord, I have underlined it, the paragraph. Article 246(3), read with Article entry 41 in the list 2 of the 7th schedule, confers upon state legislature has power to pass laws with respect to state public service, which must include judicial service of the state and denoted plan. It is a constitutional judgment. The power of control vested in the High Court by Article 235, thus expressly in terms of article itself, made subject to the law which the state legislature may pass for regulating recruitment and service conditions of judicial officers of the state. Power to pass such law was evidently not considered by the constitution makers. Kindly note it. Article 233 will not expressly give power. Expressly will not give power to Lord DPR state government. But that is what Supreme Court says. Examining Article 235. Control over the district courts, subordinate courts is vested in the High Court in order to safeguard the independence of the judiciary. It is the High Court, not executive, which possesses the control of the state judiciary. But what is important to bear in the mind is Constitution, which has taken greatest care to preserve independence of the judiciary, did not regard to power of the state legislature to pass laws regulating recruitment and conditions of judicial officers as infringement of the independence. The mere power to pass such law is not violative of the control vested in the High Court over the state judiciary. Lord, why I am making this submission, Lord? Why, Lord, DPAR will not promulgate the rules? Because allocation of business rules, Karnataka government. Meet ಮಾಡಬೇಕಲ್ಲ ಒಂದೇ ಪಾಯಿಂಟ್ ಒಂದು ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು 19 ಅಲ್ಲಿ ಇತ್ತು ನೋಡು ಅದನ್ನ ಇದ್ದೀರಾ ಮತ್ತೆ
Yes.
Lord, in V. Surendra Mohan was date of PDN 2019 4 SCC, my Lord. Interprets, my Lord, Karnataka, my Lord, the Judicial Service, it being a public service, included least 2 entry 41. Least 2 entry 41. Public service, there is an item in the Constitution. Least 2. Because Article 246 defines each list. Item 41, Lord, is included in the state list, public service. Supreme Court, while interpreting so Karnataka, the judicial service, Lord, says state having competence to legislate entry 41, state public services, state public service commission, it has also executive power under Article 154 Constitution of India. The state government was fully competent to take executive decision with regard to recruitment of civil judge junior division, supplementing the rules. My Lord may ask me the question now again myself. Why, my Lord, without amending the rules, my Lord, on 24/3/2006, DPAR passed executive order, fixing the, my Lord, promotion from the entry level to the selection grade 25% and 10% supertime scale. Because state has power in concerning the High Court, my Lord, they can supplant the rules. That is what Supreme Court says. So, in excess, the constituent power contained entry 41 leads to 7th schedule to the Constitution of India. Judicial services also include state public services. It is only state government which has competence to legislate, frame rules, issue executive order with regard to creation of district judges. Lord, again, Lord, I need not repeat it. Karnataka government transaction of business rules, Lord, I showed you Lordship's rule 17. Creation of post. Notes last Lord, Mr. Sonde, my Lord, my learned friend, senior brother, relied upon 2000, my Lord. Kindly take 2004 SCC, page 640, my Lord, which is relied by Mr. Sonde, Lord, learned brother, senior counsel, my Lord, pointing out the constitution made decision in state of Bihar versus Paul Mukund Shah. It is there, my Lord. Separate one day one side. It is cited by my Lord brother, state of Bihar. Yes, constitutional judgment, my Lord. Lord, kindly see what is the question framed by the Supreme Court, my Lord. That is very important. What happened, my Lord, in before, my Lord, while examining? State of, my Lord, Bihar passed an enactment, my Lord, reserving certain percentage of post in judiciary. That was the question examined. Kindly note it, Lord, para 2, what was the fact? What was the question? What was the examined by Honorable Apex Court? There, my lord, Bihar Judicial Service Recruitment was holding the field, prescribing reservation, my lord. In spite of that, State of Bihar passed enactment stating that these posts shall be reserved for certain category. What's the question? What Supreme Court said? Question framed is, my lord, para 17. What was the question? But question number 1, whether impugned Act 1991 in its express language covers the judicial service of Bihar. Question number 2, if answer point number 1 is affirmative, whether the provisions of impugned acts, especially section 4 of thereof, its application to subordinate judiciary would ultravires Article 233-34 of the Constitution of India, hence cannot be sustained. Question number 3, in alternative, whether aforesaid provisions section 8 are required to be read down by holding that section 4 act of the act will not apply to direct recruitment to the post comprised in Bihar Superior Judicial as specified in the schedule to the Bihar Superior Judicial Services Rules 51, as well as Bihar Judicial Service governed by Bihar Judicial Service Recruitment to 1955, comprising of post of subordinate judges Munsip under the district judiciary. But what happened? 1992 enacted, stating that all judicial service, this is the percentage reservation, contrary to the judicial recruitment rules. Then examining that question, my lord will directly come to para 62 and 63. Answer is that judicial independence cannot be taken away. Why? Because state of Bihar wanted to, my lord, say you enforce this enactment. Para 62 is the 63 is the answer, my lord. We not kindly see 61. Point number 2. Therefore, we will be answered in affirmative against the appellant state in favor of the respondent. Then not para 62. In the light of the answer on point number 2, question survives for consideration. What appropriate orders can be passed in connection to impugned section 4 of the Act? Now it is kept in view of the section 4 of the enacted Act can general operation efficacy regarding other service of the state not forming a part of judicial service of the state. For such other services, section 4 can operate its own, and in that connection, consultation of the High Court is not at all required. However, so far as it tries to encroach upon the field of the recruitment, kindly note it, and appointment to the field of recruitment, and so as far as state encroach on appointment to the subordinate judicial service of the state as envisaged by the Article 233-34, it can be certainly read down holding that section 4 of the Impugned Act shall not apply to for regulating the recruitment and appointment to the cadre of district judges, kindly note it, as well as the state cadre of the judiciary subordinate to district judge. Such appointments will be strictly governed by the Bihar Superior Judicial Service 1951 as well as by Bihar Judicial Service 55. In other words, section 4 will not have any impact on these rules and will stand read down to that extent. Once that is done, question of striking down the said rule from statute book would not survive. It would not be required. We accordingly read down the aforesaid point number 3, answered accordingly in favor of the respondent state. That means to say, state of Bihar cannot, my lord, enforce section 4 of the Act 91 in the judiciary because Article 233 and 34, State of Bihar framed the recruitment rules 55 and not 51 and 55. Therefore, my lord, Section 4 of the Act has no application because it will take away the judicial independency. If, my lord, that Act 91 is read into the judicial service. Therefore, my submission to your lordship, my lord, this judgment will no way, my lord, impact on, my lord, in this point at all. Independence of judiciary will not taken away because 2083 rules are framed under 309. 2004 rules are framed by the my lord, DPA in the High Court under Article 233, 34, 36. Again, amendment also in my lord, 2011. Again in amendment 2015. Now, my lord, Supreme Court has given a time to amend again recruitment rules 3 months, which is already over, which I have read over to the lordship. Therefore, my lord, this constitution bench judgment in no way applies while interpreting these provisions at all, because there is no, my lord, interference by the state of Karnataka in this case. If state of Karnataka imposes such certain condition without consultation of the High Court, my lord, such law will be declared void only. It cannot, my lord, intrude the power of the High Court at all. Therefore, my lord, the state of Bihar versus Bal Mukund Shah has no doesn't apply at all. It only says, my lord, Article 233-34 and rules promulgated under Article 233-34 would be applicable. That is all it says. State cannot enforce any other enactment into the judicial service, general enactment. Therefore, I showed your lordship why, my lord, the Karnataka Judicial Recruitment Service Rules Rule 11.2 says only the certain laws are applicable. Why, my lord, it says general recruitment rules, all provisions are not applicable. Why? Because it intrudes the power of the High Court. I already gave an example. Therefore, my lord, my submission to your lordship is, my lord, that judgment has absolutely no application. Then, my lord, other case law I referred in my, my lord, judgment in page 56. Onwards, my lord, which, my lord, applies the facts of this case. The learned, my lord, the judge rightly affirmed the view taken by the, my lord, the learned single judge, differing with the view. My lord, the last point, my lord, page 66 is, my lord, I have already told you, my lord, explained to your lordship, my lord, not page 66. Lord, our latest judgment of Supreme Court, where seniority list, Lord, it should be drawn 4-point roster, which is prospective law declared by the FX Court Constitution Bench. Lord, even it applies to me, my Lord, I was happiest person to, but Supreme Court clarified me it has no application. Therefore, my Lord, I just mark point number 9, page 66, I just refer that, but I made my submission very clear, my Lord, that judgment has no application. Para 97, I have already read over to your lordship. 4-point roster is concerned 19, 11, 25, Lord, Constitution judgment. Therefore, my lord, the learned judge rightly interpreted what is cadre strength, rightly said, my lord, other cadres shall be excluded in the arena of cadre strength, namely the additional list of Lokayukta. His interpretation is that, my lord, the learned the other judge judgment. the learned judge has answered. Differing with the view taken by the learned lord, the senior lord, the judge in the bench, without taking the notice of the, my lord, one more factor that I have highlighted to your lordship, lord, that is the government order dated 24/3/2006, where DPAR in Calcutta High Court affects court judgment is implemented, prescribing the, my lord, 25%, my lord, the promotion from the cadre entry level to the selection grade, 10% from the selection grade to super time scale. That has not been brought to the notice of the division bench or the single judge. I made it very clear by any parties, including these respondents. Kindly note that fact also. While laying down the law, my lord, since this is a special, my lord, bench constituted, my lord has to take into account that government order also. My lord, the learned the judge differing with the view of the senior judge, my lord, courts rule 8(7), rule 8 subclause 46, my lord, subclause 46 interprets what is cadre strength. Would it include temporary post? Para, my lord, 99, 98, 99. Then, my lord, regarding past track court judges, then ultimately, my lord, the learned judge, my lord, the differs with the view and dismisses the writ appeal filed by the High Court, directed to redraw the seniority list. Nothing else. Taking note of the, my lord, recruitment rules amended from time to prescribing quota for DR, PR, and, my lord, the promotion by limited competitive examination. And taking note of, my lord, 2000, my lord, to Supreme Court, where Supreme Court, my lord, directed to implement 40-point roster system. However, my lord, by the time when, my lord, this judgment is pronounced, 26/9/25, judgment by apex court is not there. Kindly appreciate this.
Continuing breach.
Yes, my lord. Look, I must fairly say, my lord, not that, my lord, one view this court may take. This court has to take a holistic view of the case. I am not supporting any of DR or PR here. I am only assisting this court to lay down the correct law, guidance to the, my lord, this registry. Nothing else. Therefore, my submission to your lordship, my lord, is that to sum up my submission, my lord, the writ appeal filed by the High Court requires to be dismissed. And writ appeal filed by other appellants are concerned, this court cannot consider because they are not filed reply statement. It is only High Court which has filed the reply statement. My lord knows reply statement, rejoinder, sir rejoinder, the lord again, lord reply to sir rejoinder are all part of the records of this court, my lord, writ papers and writ appeal papers. To sum up, my lord, in all, my lord, quota is breached from 83, 2005 rules, again not 2011 rules. Still, my lord, the other amendment yet to take place as per judgment of the Supreme Court in 1911, 2025 constitutional bench judgment. Though Supreme Court granted 3 months time to all the state. And then my Lord, fast track circular law is settled. My Lord has to take into the account of the judgment referred of FX court also. While my Lord considering this point, because none of the seniority list has attained finality. Therefore, my submission to your Lordship, my Lord, is concerned. Lord, I conclude my argument. I'm extremely, Lord, thankful to this court, having heard me patiently. And Lord, I have made my endeavor to, Lord, to say something about how to consider is left to this court. That's all my.
My lord, I appear for one of the direct recruits. I'm led by Senior Advocate Agarwal from Delhi. Whichever is the next date, my lord, he will make his submissions online or in person, as your lordship directs.
How much time will take?
May not take that much time because we will adopt learned senior's arguments and little bit more he wants to. Maybe 1 hour, my lord.
Wednesday 2:30.
Very well.
In advance, you submit your written submissions.
Hello. Very well.
Now, reply you must get ready. You must get ready for the reply. We are not going to permit rehearing of the matter. We have heard both in length. So reply should be limited to whatever your points. You can give your written reply in advance, saying these are the points, so that we'll have the benefit of reading and we can run through the reply.
But as far as
Now you,
I'm
on behalf
for
of
4 and R7, petitioner number 4 in the writ petition, my lord. One of the direct recruits.
the council representing the original petitioner number 4.
4, my lord.
Submits and they could advance their arguments on the next day.
Yes, my lord.
It's further directed that written submissions in advance to be filed. Relist the matter for further hearing at 2:30 on Wednesday.
Obliged.
One submission, please. Your
When any clarification required, my Lordship call for me, my Lord. I will clarify it if necessary. Otherwise, my Lord, I will conclude my argument.
one submission, please, Your Worship. Leonard Senior Counsel, Mr. P.S. Rajgopal, some inconvenience on 11th and 12th. After they both argue, he would be submitting his arguments.
Correct, but you get
No, after the High Court and Mr. Sondev, he would submit his argument.
we've given.
Just bringing,
How much time you may take?
Maybe 1 hour, my lord, but I'm not certain.
I think,
Won't be very lengthy because we'll be adopting.
You ask
13th, Nagan,
the Nagaram to be ready then. So far as the reply.
but as far as not only one submission, Lord, as far as Mr. Subramania is concerned, my lord, he has filed a impleading application. My lords said that, my lord, it will be considered along with the main, but he may take, my lord, 5 to 10 minutes.
Then on the next date, let him be ready.
Lord,
Let him be ready. On the next date, we'll hear him. After Mr. Agarwal finishes,
please,
we'll hear him.
please.
Whoever wants to file anything in written before the next date, file it. We'll have the benefit of whatever you're doing. If you've already filed, it's okay.
It's